Did you know that most California med spas and IV hydration businesses don't fail because of lack of patience? They fail because of compliance mistakes, many before they even open their doors. Hi, I'm Andrew. I'm the managing attorney here at Freedom Through Business Law Firm. We've helped start and support 100 plus medical healthcare practices here in California, from med spas to IV bars to hormone and weight loss clinics. So, if you've been thinking about launching your own business, this video is for you. Your time, your patience, your freedom, built the right way from day one. Step 1 is to choose a correct medical director. Your business actually starts here. It doesn't start with filing an LLC or corporation. In California, the medical director must hold 51% of the shares of the professional medical corporation. You would own 49% as a registered nurse or nurse practitioner. It must be noted that the medical director must be active in the practice. This means that the medical director must be active in the oversight of the practice, not just a signature on paper. To facilitate this, we schedule a 3-way meeting between you as a registered nurse or nurse practitioner and the medical director. During this initial meeting, we'll explain the different roles and responsibilities each of you will have as the medical director or the registered nurse practitioner. During this meeting, the physician as well as yourself will have the opportunity to ask questions related to the business association. This meeting ensures that our clients and the physician's visions are both aligned. No confusion, no surprises. Step 2 is to form the correct legal structure. This part is critical, and unfortunately, it's often done improperly. What people don't know is that a regular LLC, a regular limited liability company, cannot administer medical services here in California. The proper structure means forming a professional medical corporation where the physician holds 51% and you as the RN or NP would hold the remaining 49%. But it doesn't end there. You'll then want to set up a management service organization in which you as the RN or nurse practitioner will own 100%. Remember, PMC equals medical services. MSO equals business, admin, and management support. This keeps you compliant with CPOM laws and avoids illegal fee splitting. Step 3 is to sign core legal agreements. After forming a professional medical corporation, you now need a medical director agreement, a shareholders agreement, corporate bylaws plus corporate resolution, and a management service agreement. These documents protect your financial interests in the business. It also provides you with the ability to replace a medical director smoothly. And ultimately, these documents protect your license and your longevity. I can't emphasize it enough. No handshake deals in healthcare. Step 4 is to apply for a fictitious name permit from the Medical Board of California. Before you launch your brand publicly, you must apply for a fictitious name permit from the Medical Board of California. If you want to use a name such as VIP Aesthetics instead of the physician's first and last name. In short, if you do not want to use your medical director's legal name as the business's brand name, then apply for a fictitious name permit from the Medical Board of California. If you're looking to advertise without a fictitious name permit, you risk fines and disciplinary action. Step 5 is to build your clinical compliance system. Before opening your doors to the public, you need standardized procedures, medical informed consents, patient acknowledgements, treatment-specific informed consents, emergency protocol, and chart review plus prescribing policies. When it comes to a healthcare business being audited, whether that's by a client or a licensing board, the number one thing they look at is documentation. What documents do you have in order? What nurse notes have you documented? What charts have you noted? All of these are essential to being able to operate a legally compliant healthcare practice here in California. Compliance is not a binder you dust off once a year. It's a system that protects you and your license every day. Step 6 is Pharmacy and vendor setup. Remember to always use US licensed pharmacies, not overseas providers or discounted channels. California has prosecuted healthcare practices and individuals over illegal Botox and counterfeit goods. And here's an important note as an RN. RN-owned setups, you cannot have medications shipped to your home address. You need a properly zoned business address or official site. We make sure to walk clients through vendor setups so nothing gets missed. Step 7 is business licenses and banking. You'll need a city business license for each city you plan to offer services. For those of you who will have mobile units, the question I'm most often asked is, do I need a business license for every single city I plan to administer services? And the answer to that question is yes. Obtaining business licenses in the cities where you plan to administer services is not optional. It's mandatory. Additionally, you will need an EIN number for the professional medical corporation. You will also need an EIN number for the management service organization. You will need separate bank accounts, and you will also need liability and malpractice insurance. For those of you who have a physical location, remember, general liability insurance is different from malpractice liability insurance. As we know, California requires malpractice liability insurance to cover $1 million per claim and $3 million in the aggregate. Flying under the radar on business licensing, that's how investigations start. Step 8 is marketing the right way. Your website, ads, and social platforms must be compliant. Remember that the purpose of these platforms really is to provide as much educational information as possible to those who visit. In making certain claims, remember to be truthful and to never exaggerate. Most importantly, don't claim medical outcomes. Don't say FDA approved if it's not. And don't imply guaranteed results. We guide clients on safe marketing language, especially online. Step 9 is staff training and launch. Make sure to train your team on charting and documentation. Make sure staff is aware of consult workflows. For example, the good faith examination. When a patient for the first time enters through the doors of the practice, what happens? Who speaks to the potential patient? Is it an RN? Is it a nurse practitioner? Is it the medical director? Who actually conducts a good faith examination? Confirm workflows. Make sure to go over any sort of HIPAA or privacy issues with staff, especially when it comes to marketing. For example, before and afters for med spas are one of the most popular ways social media is used for branding purposes. Now, staff need to understand that they can't just go around taking pictures of patients and posting it onto the Instagram. They must obtain what's called an informed consent. What that means is the patient consented for the disclosure of their personal images to be uploaded on social media. One of the most problems we run into is that many individuals, many healthcare providers will create a photo release, a video release waiver for patients to sign. But what they fail to include in these personal waivers is education and information telling the patients that these photos will not just be used internally for internal purposes, but it will also be used on third-party applications such as Instagram, TikTok, Facebook. The bottom line is, if you're looking to disclose your patient photos or videos on your social media marketing platforms, you need to make sure that your waiver or your release, the document that patients will sign, has language informing patients that their photos will be used on third-party platforms like Instagram, Facebook, TikTok, etc. You'd be surprised at how many med spas we've worked with in the past that fail to have emergency protocols in place. Staff must be trained on post-care after procedure, but they must also be trained on emergency protocol. And lastly, make sure that staff is aware of proper med storage at proper temperatures. Handling is essential. Proper handling is essential. The stronger your systems, the stronger your protection. Step 10 is ongoing compliance and defense support. Every healthcare business eventually faces some sort of audit, investigation, a board inquiry, a patient complaint, a pharmacy audit, or even an insurance question. Most coaches can hand you PDF templates. Few can explain each requirement, help implement it, and defend you when any issues arise. We support you through launch, and we remain a resource to help you as you operate and grow, including support for audits and investigations when needed. You deserve a practice that lasts. If you are an RN, NP, PA, or medical director here in California and you're looking for help to start your own medical practice, whether that's starting your med spa or IV hydration business properly, staying compliant as you grow, and protecting your license in future, make sure you book a free call by clicking the link in the comment section below. Build your career, protect your license, create freedom through business. Let's get involved.